Hello everyone, welcome to our class today. So today is our first topic which we will be discussing, that is the meaning and importance of the criminal procedure. So what is criminal procedure, why do we need it, like what is the object of studying, and how will it benefit us in our future. Okay. So regarding these things we will be discussing a very small chapter, small subject, but it has lots of significance. So, even in exams we do not find too many questions which have been asked on this topic, but still in order to facilitate your further studies in your criminal procedure, this is the stepping stone. That is why let us begin with the today's class. So, first of all let us understand what is the object. Why do we need to study criminal procedure? What is it exactly? So, it is the law of criminal procedure is intended to provide a mechanism for the enforcement of criminal law. So, we have criminal law. Criminal law is not only CRPC. Criminal law consists of various types of law which punishes a particular person, which prescribes punishment or which describes what are the offences and prescribes punishment for those offences. So, examples are, it could be IPC, it could be NDPS Act, it could be Wildlife Protection Act, it could be Information Technology Act, it could be Motor Vehicles Act. There are so many offences, so many laws which prescribe and which describe and prescribe offences and punishments, right. So, it provides a mechanism like how, like what is it, how to deal with those laws. It is not sufficient if it is only provided in the letter. It also needs to be what I can say implemented, right. So, it has to be enforced. If you only define this is offence, is it that sufficient? No, you need to at least catch the offender and put him into the prison, then the purpose is served, right. So, that is why we need a proper mechanism for enforcing some criminal laws. Not some, we need to enforce all the criminal laws, otherwise it would be only the letter, okay, it is not in spirit. That is why that is the main object of criminal procedure. And the next object is, so this is the procedure. We have two types of laws. Generally we can classify it as two types. What are those? Those are, one is one is substantive law, another is procedural law, right. One is substantive law and another is procedural law. When that is the case, when substantive law is the case, we have examples. It defines rights, what is an offence, or if it is in a contract, what is a contract, what is a void contract, or if I take the example of Transfer of Property Act, it says what kind of property can be purchased, what properties can be mortgaged, what properties can be given on lease. So, it says that this is this, this is this, this is not this, okay. It defines certain rights and that is known as substantive law. Best example is IPC or Bharatiya Nyaya Samhita. It only says this is an offence and for this offence this much is the punishment. But procedural law is something which is very complementary to substantive law. Without procedural law, substantive law has no effect. See, best example is criminal procedure. Criminal procedure says that how an offender can be catched, how that offence can be investigated into, and how can he be put to trial, and how the offence has to be decided, and how the punishment has to be given. So, regarding all these things we will be understanding here, right. So, the procedural law is something which is kind of supportive to substantive law, and the substantive law, if it has to have some meaning, the procedural law has to be very strong. That is the role of criminal procedure here. To give more effect to the BNS or IPC, we have the procedural law as CRPC or Bharatiya Nagarika Suraksha Samhita, okay. So, that is said to be the procedural law. Then comes, so if I have to zoom it and show it to you, See here, then the next object is, the law of criminal procedure is meant to be complementary to criminal law, right, and it has been designed to ensure the process of its administration. So, it shows how the mechanism, how should be the administration of different courts, different criminal courts, how should an offence be brought into that particular court. It says regarding all these things. So, those are complementary to the criminal law and it has been designed as such. Okay. So, this is the law of criminal procedure, and the next object is very important. It is a proper machinery for detecting the crime. The crime has to be detected. The police has to investigate the case. They have to arrest the suspected criminals. In the course of investigation, the police has to collect the evidence, and depending upon that evidence, the court will determine whether he is guilty or not, whether he is innocent, right. So, all these things are dealt. So, we have so many components which we will be learning like within a very few minutes. But this is the objective of the law of criminal procedure, that is a necessary machinery for such things. Okay. And the next is, after the person has been determined as guilty, there has to be proper punishment, right. There has to be imposition of proper punishment on such person. So, this is very necessary in this case. And the next object is, it gives some human rights. It provides certain safeguards against the violation of the human rights, because see, criminal procedure involves arresting a person, detaining a person, or releasing him on bail, or like during the police investigation, he may be put in custody where his relatives or friends, family, they may not be knowing about his arrest at all. So, all these are violative of fundamental rights also, and also the basic human rights. Okay. So, in order to curb that practice, or in order to curb the practice of inhuman torture to the accused or the arrested or detained persons, or not only with regard to arrested person, generally wherever human rights could be violated, possible violation could happen, in such cases criminal procedure has provided proper safeguards. So, that is very necessary. Okay. So, these are said to be the objects of the criminal procedure, and the last object could be, what we can say is, see, one side there is a process, adjudicated process, investigative process, this machinery is there, police, judges, magistrate, they are at one side, and the other side there could be the misuse of such process, right. So, they have to be balanced. So, criminal procedure provides such balance. That is the necessity and the object also for implementing criminal procedure in a very strict manner. Okay. So, these are said to be the objects of the criminal procedure, and if we understand the next case, we can say that what is the importance of the criminal procedure, why do we need. See, in various textbooks have been referred, and they have been referred for you for the examinations also. There we have R.V. Kelkar book, there they have given 3 importance of criminal procedures. So, the first one is 3 main reasons we have. Criminal procedure is one such law which affects larger number of persons, greater number of persons than any other law. We have CPC, we have a contract, of course they are affecting, but criminal procedure is one such thing. The effect is also more, and the number of persons affected are also more. The repercussions are also more, and the people who are affected, they are also more in number, right. So, when there are greater number of persons, so many persons are being affected, criminal procedure has its role, because like arrest, maintenance, so many provisions are there regarding this, bail, or investigation, or examination of the witnesses being examined in court, police examination, so many things are there. So, it is affecting larger number of persons, and not only that, criminal procedure is one such thing where larger numbers of like human rights, human values are involved. See, a person may be there, his property may be confiscated, or he may be having a civil dispute, of course is affected by it. But if the same person, if his personal liberty is confiscated, then it is affecting him in a larger extent, right. So, we can say that human rights are violated there. So, the nature of its subject matter is such that human values are involved in it to a greater degree than in any other laws. Okay. It is not only affecting the like other laws also affecting, but the criminal extent whatever is there, it is affecting a larger number of persons. So, that is why we can say the subject matter is affecting the human values or human rights also. And the last important reason is they are complementary to each other. As a law of criminal procedure, whatever we study, without criminal procedure, there is no purpose of implementing the substantive laws like BNS or the IPC. IPC has been repealed. See, I will give an example. Now, they have defined terrorism, organized crime, petty organized crimes. They have defined in Bharatiya Nyaya Samhita. But if the criminal procedure which mentions about investigation or trial, if they do not consider them at all, what is the use of bringing into force such offences? What is the use? There is no such use as such, right. So, they both are complementary to each other. So, without procedural law, the substantive law would become worthless. It would not serve any purpose at all. That is why we can see these are the importance of criminal procedure, and they help to protect the society at large. Okay. Yes. So, we have completed the object of the criminal procedure and also the importance of the criminal procedure. And the next point is we are learning about the main segments of the criminal procedure. Okay. See, the criminal procedure, be it criminal procedure code or Bharatiya Nagarika Suraksha Samhita, whatever name be it called, it has the same concepts, same subjects you need to study, and not only for studying purpose, you need to study, you need to whatever is being implemented or whatever is being followed, they are the same, except with some procedural changes, some timelines have been fixed, some technical upgrade has been done, only with respect to these changes have taken place, and some powers of police have been increased. Okay. But the structural framework remains the same. See, suppose there is a building, okay, the basic structural building is the same. You may renovate, you may paint it, you may give some interior designs, or you may alter the some of the major design, but the structure of the building remains the same. Likewise, even now whatever change has taken place, the old law and the new criminal law, okay, it is just the renovation of the older law, we can say. The concept remains the same, the segments, the components remain the same. So, what are those? So, the first one is, the main segment is the criminal law speaks about the administration of criminal justice. There are different courts, different system of prosecution, different types of police, or different persons of what we can say, types of magistrates only we can say. One is judicial magistrate, another is executive magistrate. So, when that is the case, there should be proper mechanism which has to be provided, right. So, that is the purpose, mechanism for the administration of the criminal law, we can say like this. And the next segment is, see, the police and the courts both need to determine the jurisdiction. The police just randomly, they cannot say that we have investigation over this particular offence, we are investigating the case. No, if you lodge a complaint in a particular police station, the police station might get jurisdiction. Likewise, when you file a case in a court, the court might get jurisdiction. We do not know. It depends upon where the offence has taken place, where the act has taken place, or where the effect is somewhere else. So, there are certain rules for this. So, you need to have, you need to determine where does the police get the jurisdiction to investigate the offence, and where does the court get the jurisdiction to try the offence. So, in determining those things, we have to refer to the criminal procedure. And the next portion is release on bail of persons. So, when police start their investigation, they may arrest the accused and when such person is arrested, necessarily and definitely he will apply for the bail application. He may be released or he may not be released depending upon what kind of offence is it. It could be bailable offence or it could be non-bailable offence, right. So, this bail matter, it is not only important in investigation process, it is important in the trial process also, and it is also important in the appeal process also, it is important. Any time they may apply to the bail. Okay. So, regarding bail, bond, CRPC or BNSS has very elaborately it has dealt with those provisions. Then comes the investigation. The investigation can also be called as a pre-trial procedure. See, investigation has various aspects. First, the police get the information. Depending upon the information they get, it can be classified as cognizable offence or non-cognizable offence. So, for cognizable offences, police can start directly, they can directly start the investigation. Okay. So, that is one such thing, and the next step could be how they detect or how they suspect the offender, how they arrest him, how do they investigate. Regarding that, we can find the provisions for that. And the next provision is regarding collection of evidence. Okay, when an offence is being committed, evidence is being collected, and in that process, various persons are being examined. Okay, and they may search a particular place, they may see certain things. So, it requires different collection of evidence. And also, when police conduct the investigation and conclude them, they need to produce it before the court. The process, whatever it is, like submitting the charge sheet or challan, what you call, even that process comes under pre-trial procedures only. So, investigation is a very important step, which is a main component of the criminal procedure, which has been dealt with by the relevant law. Then comes the trial. So, the court conducts the trial, which needs to be a fair trial, a full trial needs to be conducted in accordance with the principles of the natural justice. It has to go in accordance with that, right. So, when that is the case, so cognizance of the offence, court takes cognizance of the offence and then begins with the proceedings. Initiation of the proceedings means like it may summon the accused, it may send warrant to the accused. The accused may plead guilty then and there itself. Depending upon that, it may convict him, or it may frame charges. It says that, see, these many accusations are against you, you have committed such and such offence. So, what do you say? Do you plead guilty or not? So, it will frame charges, and once charges are framed, trial has begun. There are different attributes of fair trial. See, evidence has to be taken in the presence of the accused. It cannot be in his absence unless personal attendance has been dispensed with. So, there are many provisions, the provisions of the double jeopardy, personal examination of the accused as a witness, tendering of the pardon. So, general aspects are there which we will be learning in the due process of time. And also we have different types of trials. See, trials means sessions court conducts its own trials, magistrate courts has its own trial, summons case will be tried in a different manner, warrant cases will be tried in a different manner. Summary trial, they are tried very summarily and not like more than 6 months punishment is not given in that. So, these are different types of trials we can say. And then comes the judgment. Depending upon all the trial which has taken place, the court will pass the judgment. Okay. Judgment also, it has a particular format. Some things have to be there, accused needs to be present, copies needs to be given, right. So, these are the different aspects which we learn under the trial, and which is a very important component of the criminal procedure. So, once judgment is given, the higher court needs to review the decision by way of appeal, or it could be revision also, it could be by review also. The higher courts need to decide, right, whether this is proper or not, whether the lower court has given a proper judgment, whether it has properly appreciated the evidence. So, it sees that. Then comes the execution of decisions. See, lower court and the higher court, they have passed the sentence. So, that is up to their job is done. But the sentence needs to be implemented. The accused needs to be spent in jail. Who decides that? Who will go to jail? he will be sent to which jail? So, all these are decided by the government, the state government, right. So, that is the execution of the sentence. So, what kind of prisons he must be allotted, and regarding his expenditure, or should he be put in solitary confinement, whether what kind of rigorous punishment has to be given. So, all these will be decided by the state government, and even with respect to the mercy petitions which has been included, a newly included provision BNSS, mercy petitions, they also find way in this component only. And also commutation of sentence, the amount of sentence is reduced, remission of sentence. So many things we are going to learn in this execution of the sentence, and it has various aspects and various dimensions, okay. But we can classify them as the main component of the criminal procedure. So, till here what we learnt, see, right from the commission of the offence, okay, when an offence is being committed, how the information is given and it is sent to which court with respect to the jurisdiction, and how those courts are administered, and how the investigation is being carried out, and how a person is being released on bail, and how trial is conducted, how judgment is given, how such judgments are reviewed, and how that judgment or sentence has been implemented. So, till then we have understood them, and apart from this, the criminal procedure has other components as well in a different manner. See, the maintenance provisions can be found in criminal procedure, maintenance of wives, children and the parents. See, nowhere it is not applicable only to a particular religion, irrespective of any religion, irrespective of like whatever religion, this code, this section is applicable for everyone. They have to maintain these persons who are unable to maintain themselves. That is one such unique provision, okay. And regarding prevention of offences, see, we see that executive magistrates or sometimes judicial magistrates also, they can take the bond for a period of 1 year up to 3 years from habitual offenders who are suspected criminals. They can take bond from them for keeping peace and for keeping good behavior, okay. So, that is one such thing we can find under prevention of offences. And also police also have certain power as per BNSS, they can prevent the offence by arresting a person if he is found suspected. And the last portion is public nuisance. So, public nuisance is also the magistrate, that is a district magistrate, he is having the power to issue conditional order for removal of the nuisance. He can issue some prohibitory order, section 144, a very famous section under CRPC, right. So, regarding or section 133, public nuisance section. So, they have certain powers to remove public nuisance. So, this not only with respect to a particular offence, but also other segments are also included where the overall health of the society is maintained, right. So, that is why CRPC or criminal procedure is very, very important. Be it might have been it might have changed its form and has a new look in BNSS, but still the major structural components are the same, they do not differ, okay. So, this was all about our today's class, and hence I conclude this portion, and the next chapter will be regarding Bharatiya Nagarika Suraksha Samhita salient features. We will be studying regarding that, and see you in my next video. Properly understand the topics and make a proper notes out of it, so that you will understand in a better manner, okay. So, I like to conclude my class here. So, thank you for your patient listening. See you in my next video. Take care. Bye bye.